Hey everybody, this is Attorney Andy Marcantel from the Attorneys for Freedom, and congratulations to Arizona for just passing Prop 207, now officially making marijuana legalized for recreational purposes. Congrats to the voters for doing the right thing to promote freedom in the state. We had previously had it in Arizona so that it was legal for medicinal purposes, which is nice. It was certainly an improvement upon the previous state of the law. And it's nice too that marijuana has some medicinal purposes and has helped people, for example, get off of prescription drugs and alleviate pain and be able to sleep. And these medicinal purposes are certainly nice. But that's not what the main issue is, right? The main issue is about freedom. And the main issue is that competent adults own themselves. They own their own bodies, and they get to put whatever they want in their own bodies so long as they do it peacefully and don't aggress against others. Prop 207, while not perfect, definitely pushes the bus in the right direction when it goes to these types of freedom arguments. So we said a lot about this. Our law firm has released a lot of videos with information about this. I would strongly encourage you guys to check out some of the videos created by Mark Victor, in which we talk about the strengths and weaknesses of Prop 207. It's certainly, as I said, not perfect, and I would strongly encourage everybody to check out those videos just to kind of give a brief overview of it. It's going to be effective very likely on the 30th of November 2020, meaning that a certain amount of possession of both the concentrate and the flower will be legally available to people to possess recreationally. And then there's an expungement provision that'll be activated in July of 2021. I would encourage you to go check out some of our other videos for more details about this. But the purpose of this video today, I have a very specific purpose, which is to talk about marijuana DUIs and what are the future of marijuana DUIs in the state of Arizona now that 207 has passed. What does Prop 207 do to the state of marijuana DUIs? Because there are provisions that you may have seen that alter Arizona marijuana DUIs that are found in Prop 207. And then also some of my predictions on what I'm expecting to see from the justice system, both from police and from prosecutors, over the course of the next few years while we kind of navigate and figure out this largely uncharted waters regarding this issue. So let's talk about 207 and how it affects marijuana DUIs. And this is an important topic for a lot of people, right? You may have seen, if you were driving around town and you saw some signage, some kind of pro 207 stuff and some anti 207 stuff. The majority of the anti 207 stuff had little slogans on it such as say no to increased DUIs and save the children, these kind of morally based arguments that the children are going to be corrupted if we legalize the evil green leafy substance, and people are just going to be swerving all over the roads, causing major problems. We're going to see a giant spike in marijuana DUIs if 207 were to pass. These were kind of the same old kind of tired arguments that were made by the opponents of 207. It's been done in many other states that have already are leading the charge on legalization of marijuana. These were the same types of arguments that we heard from the opponents in those states, such as Colorado and California, which of course, by the way, turned out ultimately to not be true at all. But because these were some major concerns, 207 does a few things, tosses a few bones to those people, you could say, in an attempt to kind of alleviate some of these concerns. Well, one of the provisions of Prop 207 is a fund is created to fund several different notable projects in the community. But of that fund that's created from the taxation revenue of recreational marijuana, $10 million of it is to be allocated towards DUI prevention and policing and basically detection, prevention, policing, enforcement of DUI laws. And it specifically talks about DUI laws in 207. This is going to be an important issue moving forward. because I'm expecting to see, for that reason, whether just or not, I'm expecting to see an increase potentially in prosecutions of DUI. Now, it doesn't mean necessarily convictions of marijuana DUIs, and it doesn't necessarily even mean that those prosecutions will be just in any way. In fact, I'm expecting to see, for the reasons I'm about to explain, I'm expecting to see more unjust prosecutions of marijuana DUIs, at least over the next couple of years, while we're hashing out all these concepts in the justice system. But let's first talk about one of the major injustices that is actually corrected by Prop 207 when it comes to this area of marijuana DUIs. So up until this point, DUIs for marijuana have been charged under several different statutes, the most notable of which is ARS 28-1381A3. We kind of shorthand call it the A3 DUI. That's how the attorneys kind of shorthand it. So the A3 DUI, we've said a lot about this DUI. If you've searched our position for DUIs and why we think certain areas of DUI law in Arizona are unjust or immoral or just statutorily not well founded. A3, we've had a lot to say about this DUI because curiously, A3 is a DUI under Arizona law that does not require impairment as an element of the crime. All it requires is that you have any trace amount, any detectable amount of an illegal drug specified under the criminal code in your system at the time while you were driving. Impairment is not an element of an A3 DUI. So in other words, you could have a small little tangential trace of active THC in your system under the A3 DUI and then still be not felt the effects of it for hours and hours and still be a DUI under Arizona law under the A3. So this has been a long time injustice. Now granted, there were a few exceptions for medical marijuana patients that were kind of carved out in case law. But for the people who were using marijuana recreationally, so far, any amount in their system whatsoever was enough for a DUI. And active THC stays in your system for an average of anywhere between 6 to 24 hours, usually, depending on a number of factors. So I would always tell my clients, hey, if you smoke marijuana in the morning, according to an A3, the laws of A3, you're a DUI maybe until the next day, definitely until maybe that evening. So just kind of treat it as if you're a DUI. If they pull you over and they draw your blood under the A3, you're a DUI maybe for up to 24 hours. So one of the things Prop 207 does is it corrects this long time injustice. It says, no, we're going to pull it out of the A3 world. And we're going to put it into a different statute. So the statute that marijuana DUI is now kind of umbrellaed under is 28-1381A1. We call it the A1 DUI. And you've probably heard the standard that A1 operates under, which is impaired to the slightest degree. So now impairment is actually required to be proven by the state beyond a reasonable doubt as an element of the crime. So just like we would exempt, for example, with alcohol, where if they have to prove that you drank at least enough alcohol such that you were impaired to the slightest degree at the time that you were operating your vehicle, now they have to do the same thing with marijuana. So I think it's nice that now, the law has changed to actually require you to be impaired by the marijuana in order to get a driving while impaired conviction. I think that's a good improvement. So the question then is, how are the cops, how have they historically, and how will they moving forward? How do they prove impairment? How do they prove that you've consumed at least enough marijuana to impair you to the slightest degree? And there are a lot of different ways that cops attempt to prove this and that prosecutors subsequently try to prove this in court, maybe even to a jury. And they include things like traffic violations, right, that the cops observe. The cops may observe you swerve into a different lane, initiate a traffic stop, and use the observed traffic stops that they saw while pursuing you prior to the traffic stop that they conducted. They may see the traffic violations and use those as proof that you were impaired, right? You can see a prosecutor saying, ladies and gentlemen of the jury, he was swerving all over the road before the cop pulled him over. Therefore, that's evidence that he was impaired at least to the slightest degree by the marijuana. There's lots of other ways that cops and prosecutors try to prove impairment beyond a reasonable doubt, such as admissions. Oftentimes, suspects will make admissions. Yeah, officer, you got me. I drank the beer an hour ago, or I smoked the joint 30 minutes ago before getting in the vehicle. People tend to talk to the police, which is ill-advised. If you've talked to any defense attorney, you should not be talking to the police and making the state's case for them. But unfortunately, no matter how many times we as defense attorneys harp on this over and over and over again, ultimately people are going to end up waiving their right against self-incrimination and just chatting with the police and admitting to use of alcohol or drugs or whatever it may be. Then there's the field sobriety tests, or the silly games on the side of the road, right? This is where the officer says, step out of the vehicle, sir. Now I want you to imagine there's an imaginary line in front of you, and I want you to go heel to toe 9 times and then do a body pivot and then come back the other way and put your leg up and touch your nose and balance and count things in your head, and the big battery of crazy games on the side of the road. Well, the officer who has a direct incentive to arrest you and to prosecute you and to forward the case for prosecution is the person who's solely responsible also to evaluate how you did on these tests. So as you can imagine, these tests don't usually go well for defendants. Usually the cops say, oh yeah, they had all kinds of cues of impairment all over the place, regardless kind of how you actually did. And a lot of these tests are difficult enough that you could display cues of impairment even stone cold sober. They're oftentimes, it seems oftentimes that they're set up to make you fail. So take this as your friendly PSA reminder from a defense attorney who's done many, many DUIs over the years, that you should not submit to those field sobriety tests on the side of the road. Arizona law does not require you and does not punish you for refusing to submit to those on the side of the road. And I want you to blame it on me. You can say, hey, officer, I saw this video with this crazy DUI defense attorney named Andy, and Andy said I am not allowed to submit to those under any circumstances. And I'd like to call him. If he says that I can do them, then I'd be happy to do them, but I'd like to call an attorney right now. So feel free to blame it on me if the officer asks you to do these tests. Usually that'll shut it down, but I can tell you that in defending many, many people over the years charged with DUI, the people who don't submit to all the crazy games on the side of the road and actually know their rights and choose not to indulge in this self-incrimination process of field sobriety tests and crazy games, those cases are usually a heck of a lot more defensible when the case gets to court. So don't do the state's job for them. Take this as your friendly PSA reminder. The main way that the state is going to attempt to prove that the driver was impaired to the slightest degree by marijuana is through their blood. Okay, so what's going to happen is if they make an arrest on the scene, they're going to transport you over to the police department. At that point, they're going to draw your blood. You're either going to agree to have your blood drawn, which is actually kind of required by Arizona law. If you do not submit to the blood draw at that point, what they're going to do is they're going to suspend your license for 1 year. They're going to get a telephonic warrant really quick from a judge or a commissioner. And then they will present you with the warrant and say, well, we just got the warrant. We're going to now hold you down and draw it by force if you don't comply. So long story short, you should submit to the blood draw when you get back to the station because you're going to have to do it either way. And the first way is much more pleasant because it doesn't involve a 1-year mandatory license revocation and a potentially horrific situation with police holding you down and jabbing a needle in your arm. So after they draw that blood, they're going to send it over to their crime lab. The crime lab is going to break it down, and they're going to get several different types of lab test results. One is going to be qualitative, which basically shows, yes, these are the substances that his blood showed positive for. So they kind of do a general screening of each of the types of drugs that they're set up to detect. And then the ones that come back positive, you can then get a more in-depth quantitative result, which is, okay, well, what is the actual concentration of that? And with THC, the way that we measure concentration of active THC in your system is through a measurement called nanograms per milliliter, which is exactly what it sounds like. It's a measure of per milliliter of blood in your body. What is the concentration of nanograms of active THC in your blood? So here's the $10,000 question. How many nanograms of THC per milliliter in your blood does it take to impair you? And the answer is the jury is still completely out on this. The science is all over the place. Nobody agrees on this, and the authorities are all over the place. Some prosecutors that I've encountered believe, oh yeah, you have 1 nanogram of active THC in your system. That's enough to impair you. Then you've got places like Colorado. Colorado has attempted to do something kind of similar to how we have presumptive limits of alcohol concentration in your blood, BAC. For example, you know probably in Arizona that the presumptive limit is 0.08. And then there's different presumptive limits for extreme DUI at 0.15 and super extreme DUI at 0.2. Colorado's tried to do a similar thing with marijuana concentration. And so in Colorado, they say, you know, we've chosen the number 5 nanograms per milliliter of active THC in your blood is equivalent roughly of being 0.08 with alcohol. And they've based that on numerous studies and numerous authorities that they claim are credible. And so what it does is if you have 5 nanograms per milliliter of active THC in your blood in a state like Colorado, then there is a rebuttable presumption created that you are impaired. So that's how Colorado has dealt with it. Still other authorities, very credible authorities, and many different scientists have concluded all kinds of other things, such as a 13.1 nanogram per milliliter, being kind of the benchmark zone of where you would be presumptively impaired, where the average person would be presumed to be presumptively impaired, which is obviously much, much higher than Colorado's standard or the crazy prosecutor's standard that I talked about earlier. And still other experts say the concentration of nanograms per milliliter has nothing to do with how impaired you are. And it has very little correlation to how impaired one can be, because there's all these different factors that determine how much THC actually impairs somebody, such as body fat index, metabolism rate, frequency of use is a huge one. If, for example, you use every day for a year or two, then your tolerance will be raised to the concentration, such that it'll take a heck of a lot more nanograms per milliliter to impair you. I've had an expert testify in one of my cases where I had a client come back with 25 nanograms per milliliter. The expert concluded, no, based on all these factors, metabolism, body fat index, all that stuff, and the fact that he's been an active medicinal marijuana user for the last 6 years, leads me to the conclusion that 25 is either insufficient to impair him, or it's totally, you just can't prove it beyond a reasonable doubt that 25 nanograms per milliliter would impair somebody like this. So bottom line is the science is all over the place. The experts are totally divided. And so these are interesting discussions that we've been having that are only going to increase in the courts with the passing of 207. So what they're looking for, just kind of keep in mind a couple of things. What they're looking for here when they're running your blood and testing it, they're looking for active THC. That's the active component of marijuana that actually impairs you. There are, for example, many inactive metabolites of marijuana, such as carboxy-THC, that can linger in the body for weeks, sometimes even months, but it doesn't impair you. It just kind of sits there inactively. And that's not what they're testing for. They're looking for active THC. Active THC, as I mentioned, can stay in your blood on average. I know it's kind of a big window, but it's an accurate one. On average, between 6 and 24 hours. Once again, depending upon many, many factors, such as your metabolism rate, how much you've had to eat, body fat index, all kinds of other factors as well. And so frequent users can actually, even if they stop using marijuana, they can actually have a residual amount of active THC that's detectable in these tests for days. So there's a certain danger involved with frequent use that isn't present in occasional use when it comes to detectability in these tests. So let's look at the facts before we kind of dive into what I think is going to be happening in the court systems in Arizona over the next couple of years. Let's look at the facts, what we know from other states that have legalized marijuana recreationally. The facts are that there hasn't been any evidence, any concrete evidence whatsoever in any of the states that have legalized marijuana for recreational use that DUIs have increased. No evidence whatsoever. You would think that if opponents of 207 had something they could point to, some kind of a study, some sort of proof or evidence, that they would have been all over it. And there's a reason you didn't see them pointing to any such studies, because they don't exist. There's no evidence that DUIs increase in states that have legalized it either medicinally or for recreational purposes. But this is the part that might shock people. Not only is there no evidence of increased DUIs, in these states, but there's actually no evidence of increased use in these states. And that seems almost counterintuitive. You would think that if they legalize something, more people would do it. There's no evidence that use has even gone up of marijuana in states that have legalized it. There's even a study out of Colorado that suggests that it's actually use of people who are under the age of 18 has actually decreased since it was legalized in Colorado. So, these are what the facts are showing right now, what the studies are showing. In other words, the sky is not falling as many opponents of legalization were arguing and had believed for so long. So my concern is that given that this area is full of conflict and that the science is split and that this is, kind of uncharted waters in many respects in Arizona, and also given the fact that $10 million has been allocated to law enforcement to crack down on all the DUIs that are supposedly coming as a result of 207 passing. My concern is that over the next few years, while this kind of works itself out in the court system and we start to hammer down these concepts more, is that police are going to be erring on the side of making arrests where possible. Now, 207 is really clear that simply the smell or the sight of marijuana, for example, is no longer sufficient probable cause to arrest somebody. But if you couple the smell of marijuana with something like a traffic violation that they just observed 2 minutes ago before pulling you over, or you couple the smell of marijuana with something like poor performance on all the crazy games on the side of the road, or an admission that, yeah, officer, yeah, I did use marijuana, but it was 5 hours earlier. I haven't felt the effects in a long time. What's the big deal? Haven't you heard, officer, that 207 passed and it's legal now? Well, I think cops are going to err on the side of saying, all right, step out of the car, sir. I have some more questions for you. I have some tests I want to run. And so I think that the cops are going to err on the side of arresting people who make confessions or they smell marijuana or something like that. So people are going to think that they're innocently making statements. Yes, I do have marijuana on my person, officer. It's legal now. Yes, I did use marijuana this morning. But keep in mind, cops aren't always going to believe that, right? If they smell the marijuana and you say, oh yeah, it was 8 hours ago, they may be skeptical. Cops are lied to on a pretty regular basis while they're doing their job. So they may say, no, okay, I smell it. I'm guessing this person's used it more recently than that. Step out of the car, sir. Let's do some field sobriety tests. And keep in mind, too, there's a distinction between fresh marijuana and burnt marijuana. Whereas smelling fresh, unburned, unused marijuana may not provide the probable cause in and of itself necessary to say that somebody is a DUI. If they claim to smell burnt marijuana, in my training and experience, the smell that I smelt was not fresh marijuana, it was burnt marijuana. Then they can say, see, that's evidence that you were smoking while driving or present in your car. Therefore, it stacks more on the side of probable cause to arrest. So they make these distinctions, and I don't think that the fact that 207 specifically says that the mere smell or sight of marijuana is no longer enough for probable cause, I don't think we should take that as, oh, thank goodness, now cops won't be arresting people for marijuana anymore. There's so many nuances to this, especially when it comes to something that's fraught with peril like a DUI stop. That has so many different ways that the cop can either get you to incriminate yourself or that they can incriminate you. So the problem with the fact that nobody agrees with how many nanograms per milliliter it takes to impair you is because it gives the prosecutors a lot of discretion, right? I mentioned the crazy prosecutor who I have dealt with in the past, who they say that, oh yeah, any amount of active THC whatsoever is enough to impair you, at least to the slightest degree, even though no credible scientist would take the stand and say, yes, just a tangential amount is enough to impair this person. Prosecutors believe it, and it's a costly procedure to go to trial, to put on a trial and have to try to convince a jury. And also, I mean, you've probably gathered this from how staunch some of the opposition was when it came to 207 passing, that this is kind of a morally charged issue for some people. For some people, drug use has a moral twinge to it, that it may be dangerous to get a randomly assembled jury and take something like this to trial, because you may just end up with somebody on your jury who hates marijuana and thinks marijuana use is immoral. And so, you know, bottom line is the prosecutors are going to have a lot of discretion when choosing whether or not to charge these things. Right now, there are no presumptive limits in Arizona like there are in Colorado, where we say, here's the amount of nanograms per milliliter it presumptively takes to impair a human being. Right now, pretty much the prosecutors run the show. There could be a prosecutor that makes his own personal policy that I don't charge these things if they're under 5 nanograms per milliliter. And there could be prosecutors that say, I'm going to charge every single one of these that comes across my desk. There's a financial incentive to do that as well, right? I don't know if you've ever known anybody or personally been charged with a DUI or convicted of a DUI, but the city gets thousands of dollars per conviction in fines, thousands of dollars. Usually over between $2,000 and $3,000, even for your first time DUI. And if it's a second time or an extreme DUI or super extreme DUI, it's much more than that. It's many thousands of dollars that the state directly benefits from every single time somebody gets convicted of a DUI in their jurisdiction. So there's a financial incentive to charge as many of these as possible and procure as many convictions as possible. So that will undoubtedly, and it shouldn't obviously, and not for every prosecutor does it, but it will undoubtedly, unfortunately, I think, motivate more of these prosecutions. If you or anybody you know is arrested for DUI in the next couple of years, keep in mind how uncharted this territory is. What's going to be happening over the next couple of years, attorneys are going to be fighting in the courtroom about things like how much concentration of THC in the blood is required to actually impair someone. What should we take as signs of impairment unrelated to the blood? How accurate are these field sobriety tests in actually measuring cues of impairment? There's going to be so many areas that we need to establish over the next couple of years. And if the police are erring on the side of simply arresting and the prosecutors are erring on the side of charging these cases, the end result is going to be, there's going to be a lot of unjust prosecutions for marijuana DUIs. There's going to be a lot of cases that are charged that should not be charged. And so that's why it's going to be so important for defense attorneys over the next couple of years while the courts are figuring out how to deal with this brand new issue, to really challenge these things and fight these things very aggressively. The defense bar has got to be good on this issue. Just like any other issue, the state is only as good as the defense bar is good, right? We need to hold them to their burden in each and every respect so that this isn't used as a tool of invading people's privacy or people's property or people's person. And so that's why it's so important to get a good, aggressive defense attorney to challenge a case like this. Now, we are an activist law firm. If you know anything about our law firm, we've been very loudly and very unabashedly calling for legalization of marijuana recreationally for all purposes for years even before it was legalized medicinally. And we speak about these issues all the time. For us, it's a freedom issue. It's the fact that competent adults own their own bodies. And if some people get medicinal purposes and effects and benefits from it, that's wonderful and everything. But that's not the issue. The issue is you should be able to put whatever you want in your own body, so long as you do it peacefully and so long as you don't aggress on others. Even if it were bad for you, you should be able to do that. Now, obviously, when you use a significant amount of marijuana and get behind the wheel and go swerving all over the road and create a giant risk of harm to your fellow human beings, you are not using the marijuana peacefully. And I think that some people are acutely dialed into this point and think 207 is going to open up floodgates to more and more people to using it in an irresponsible and reckless manner. I think that oftentimes the police in making these arrests are going to be motivated by absolute good faith, the best of motivations, thinking that they're helping to prevent people who are causing a danger and a substantial risk of harm to others. And I think that drive is unfortunately going to result in many unjust prosecutions. Now, granted, there will be police officers that are making unjust arrests and not operating in good faith. But for those who are operating in good faith, I think that motivation, that zealousness is going to result in a number of unjust arrests over the next couple of years. So very, very important that this entire area of law be aggressively challenged in court by defense attorneys. You should visit our website. I mentioned other videos that Mark Victor has made talking about these issues, where we break down 207, the nuances of it, the pros of 207, and the things that maybe aren't quite perfect. It's not a perfect bill. Very rarely is an initiative or any law perfect, but it's definitely a step in the right direction in many regards. So go check out our website, attorneysforfreedom.com. There's tons of videos, tons of information on there on this subject. Also, while you're there, you should consider checking out our Attorney on Retainer program. What this program is, you pay a small monthly fee for the right to retain our law firm, for drastically reduced fees if you ever are charged with a crime. You have to sign up for the program first, have us on retainer, have us on this plan, so that if you ever are charged, you're going to get drastic reductions on your legal fees. There's all kinds of programs on there, so you can try to look around, see if you can find one that's the right fit for you or your family or your business. We have self-defense plans on there for firearms owners, in which case, if you're ever required to use your firearm in self-defense, for example, all of your legal fees, including up to and through trial, are completely comped, as long as self-defense is a viable defense in that case. So there's all kinds of different plans. I encourage you guys to go check it out. Check out all the other information on there. Send us your questions. We love it when people send us questions in response to these videos. Oftentimes we take the best questions and we make them into promotional videos for our Attorney on Retainer clients. So keep your questions coming. This has been Andy Marcantel. It's been my pleasure to talk to you guys today about 207, Prop 207 in Arizona and its effects, projected effects on the legal system when it comes to DUI enforcement and prosecution. If you have any legal problems at all or just want to chat about any of these issues, don't hesitate to reach out, attorneysforfreedom.com, or you can call our office. We look forward to talking to you about your legal issues. Have a wonderful day. Thanks for tuning in.